Hello, everyone, and thanks for joining us today. I'll start by acknowledging the traditional owners of the lands that we're all joining from. In my case, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders. Great to see such strong interest. I think we've hit we're almost at the magical 100 point. So great to see such interest in this webinar about the future of the rail system and the importance, these important reforms to rail safety national law. We've got, as a country, over 30,000 kilometres of rail. We move millions of passengers every year, as well as billions of dollars of freight across the cities, regions and remote areas. And as our country grows, the demand for rail is only going to continue to increase. But as we all know, our rail system started as a collection of separate networks, each designed to meet local needs, and those have progressively merged over time, but with different rules, technologies, ways of working and approaches to worker training. That makes it hard for rail to operate as a single connected system, drives up costs, productivity, and can ultimately affect safety and reliability. So that's why reducing these differences across networks and achieving greater consistency is a priority of National Cabinet. It's a key driver of the reforms underway through the National Rail Action Plan and the recently completed review of rail safety national law. So in 2024, for those who don't know, we undertook a targeted review of the law at the request of Australia's infrastructure and transport ministers. First review of the law since it came into effect in 2012, so it was a good time, 10 years to go back and see, is it working? The review made a series of recommendations, including to better align safety and productivity, promote innovation and embed interoperability outcomes to the law, but also to strengthen the regulator's ability to address national barriers in areas such as technology approval and workforce skills, and trying to remove some of the unnecessary duplication and improve national consistency. And there was also a strong focus on promoting greater transparency and information sharing, and that'll be something that we cover in a bit more detail today. The review also made the point, though, that while the law has been operating effectively to support safety, it wasn't ever designed to address national challenges like interoperability, harmonisation and workforce mobility. And importantly, at the end of this review, we went back to ministers and ministers endorsed all the recommendations. At that same time, ministers also agreed on a series of related landmark reforms, including adopting ETCS as the digital national signalling standard for the National Network for Interoperability and strengthening national standards governance. And I know we'll touch on that again today. So together, these reforms are all about positioning rail for the future, improving safety, productivity, supporting sustainability and allowing rail to play a bigger role in moving people and goods across the country. The proposed changes to the RSNL are about providing a legislative foundation to support that future. So it's not all of the work, but it does provide the legislative underpinning and the legal rationale to be able to do this. They don't change the fundamental safety duties of rail transport operators, and safety remains the primary objective of the law. So today's session, we'll step through the proposed legislative reform options set out in the Consultation Regulatory Impact Statement, or CRIS. So you'll hear CRIS being talked about a lot today. And explain the consultation processes and the feedback being sought. So there'll be a lot of content and some important stuff about process as well. There'll also be time for questions at the end. We've got a big turnout today. I see 119 at the moment, so please pop your questions in the chat and we'll get to them at the end. Look, we really value your time today, but also your input and participation on this. So the feedback that we get will directly inform the advice that we provide to ministers on the next steps. We'll be recording this session and it will be made available via our website for the duration of the consultation period, so you can come back to it at any time or distribute it within your organisation. So I reckon that's about enough from me, and I will hand over to Dimmy, Mel and the wonderful Tom Sargent. Thank you.
Yeah, thank you, Michael, and nice to see everyone today. Thank you for your time. In the interest of getting to the questions bit and the interactive bit, I'll go through this relatively quickly because Michael gave such a good intro. As we said, we'll go through for a bit of a refresher for those that either don't remember or weren't really part of the review process in 2024, and then we'll focus on what the legislative recommendations were across those two broad areas of interoperability and transparency and accountability. And we'll go through some of the options in the series to just explain it a bit, give it a bit of colour of movement and maybe some words as opposed to just words on a page. So next slide, thanks, Leo. As Michael said, back in 2024, we completed the review, the NTC, together with Tom Sargent. We spoke to many, many stakeholders across operators, unions and governments about how the law worked in practice and what could be improved. Broadly speaking, as Michael has said, you know, the law was working well, but there could certainly be tweaks and improvements. And certainly the concept of interoperability, which was quite new, certainly could be embedded in the law to give the real push for that and to deliver and achieve the productivity outcomes we all wanted. More specifically, interface agreements were also a bit of a hot topic because we realised that in practice those things weren't working as perhaps was intended in the law, and certainly to embed the regulator with a national focus, given it's a national network, to share learning and what's going on sort of nationally as opposed to state-based or network-based, which was historically the lens that these reforms and this law was developed. Okay, thanks. Next slide. Yeah, and at the same time, as Michael said, through National Cabinet, ITM also had rail interoperability as an absolute key focus and priority. So we thought it became a really clear opportunity to dovetail those two pieces of work into one, and making sure that the law was doing what it could to maximise interoperability outcomes, noting that it is only one part of the story. So we've now merged into this series both the legislative reforms from the review as well as any legislative requirements around standards and institutional governments and standards as well to get that seamless outcome. Thanks. Next slide, please. So as I've mentioned, the series is based under two broad themes: reforms around interoperability and reforms around transparency and accountability. So the series itself covers three broad options against each of those recommendations. Some of them are very specific recommendations, and some of them are much broader and go more to a sense of the kind of improvement as opposed to something really, really detailed. So where possible, we've started with three options. The first one being sort of non-regulatory or collaborative, more like things like memorandums of understandings, that kind of thing. Then there's a legislative change, which is a lighter touch, and a legislative change that is broader and stronger. Now, not each of those recommendations lend themselves to one of these options. So where it doesn't make sense, obviously all three don't appear, but that's the general lens that we've thought about how to best implement the different recommendations. And ultimately at the end, and we'll get into this, we need this to work as a cohesive package of reforms. And so we're really interested in talking about how it's all going to work together in practice. And it might not always be kind of a one-for-one option in the end. Some of that may, a particular legislative reform may achieve multiple recommendations. Thank you. I might hand over to my colleague Mel now.
Thanks very much, Demi, and good afternoon, everyone. The review found the connection between safety and productivity in the law could be strengthened, as Michael mentioned. This wasn't the original intention of the law when it was first designed, but there are opportunities in the law to drive interoperability outcomes and to promote innovation and productivity. Importantly, this can be done without compromising safety, which remains the primary objective of the law. I'm going to step through the first set of 7 interoperability recommendations. I'll go through the three options, if there are 3 option areas that we're considering and we'd like your input on, but I'm not going to go into a lot of detail underneath them because there's a lot more in the series document itself, which I really encourage you to have a look at, but we'll step you through how this all sits together. The first recommendation from the RSNL review was that the link between safety and productivity in the law be strengthened, and that this could be achieved through the guiding principles of the law to enable the regulator to play a more active role in identifying and resolving national barriers to productivity where appropriate. But importantly, any productivity considerations would be balanced against safety outcomes. So this approach is particularly relevant for the NNI, where mandated interoperability outcomes, or the National Network for Interoperability, I should say, where mandated national interoperability outcomes really need to drive national consistency. So we have three options here. That non-legislative mechanism that we're exploring is around a ministerial statement or a statement of expectations for the regulator to report on initiatives to improve productivity as part of its safety and productivity plan. The second option is that lighter touch legislative reform is around highlighting productivity or efficiency as a secondary principle under the law. And then there's a stronger legislative reform around potentially highlighting productivity or efficiency as a key principle in the rail safety national law. So that's the sort of schema that we're looking at for each of these. For the second recommendation area around the regulator having a more explicit role in coordinating and facilitating national safety and productivity improvements, this could look like the regulator identifying barriers and bringing forward opportunities for ministers to consider as part of a national safety and productivity improvement plan. It could be particularly relevant in areas like equipment type approvals, rolling stock registration, safety assurance processes. The options we're exploring here, again, that first non-legislative area around a statement of expectations in that space. The second is a light touch legislative reform to give the regulator an explicit role under the law to deliver safety and productivity benefits through interoperability and harmonisation. This is one of the recommendation areas where we don't have a third. There isn't a stronger option proposed under the law, but if you've got a suggestion or you believe it needs a stronger focus, we're definitely interested in hearing as part of your feedback. Recommendation 3 is very much related to interoperability, and provisions be established in the law to enable the mandating of requirements to achieve interoperability outcomes. These requirements are quite targeted. They're focused on areas that deliver measurable safety and productivity benefits across the national rail network. The intent is to provide a legislative mechanism to support interoperability agreed priorities rather than relying on voluntary uptake. So the areas we're exploring in the consultation RIS here is a non-legislative mechanism for operators to, we've got the interoperability management plan requirement that commenced at the end of last year, and we've got a transition period through to now, but to build on that and really lean on that to consider interoperability issues in accordance with those requirements. Then we've got a proposed suggested option 2 around a lighter touch legislative reform to add interoperability as a subpart to the RSNL general safety duty that applies to operators right now, and including requirements for mandatory Tier 1 standards. The third, which is a stronger legal emphasis, is to introduce a separate explicit duty on rail transport operators to manage interoperability requirements, again, requiring them compliance with mandatory Tier 1 standards as well. Recommendation 16 is very closely related, that interoperability be listed as an objective in the law. This would emphasise the importance of interoperability in achieving national rail safety and productivity outcomes. But it's builds on the already ministerially approved requirement for rail transport operators on the NNI to have that interoperability management plan as part of their safety management system. So in this regard, we don't actually have a non-legislative option that we're suggesting at this point. So option 2 is that lighter touch to amend the rail safety national law to include interoperability as a secondary object. Option 3 is to include interoperability as a key object and guiding principle in the law with equal weighting to safety. Do note here, to the extent that interoperability and safety duties had any conflict, safety duty will definitely prevail, but this is something we're exploring in the law. Go to the other 3 interoperability recommendations. Recommendation 18 is that rail infrastructure managers be compelled to consider implications to the wider network when they're implementing network rule or infrastructure changes. So this is around a requirement to consult with interfacing rail transport operators and having a regard to the impacts on the wider rail network, recognising that the rail operates as an interconnected system nationally. So the intent here is to avoid decisions that create new interoperability barriers. It's about embedding a national rail system mindset. The options we're exploring are a non-legislative option around an industry code, which supports also the current interoperability management plan requirements. The second option that we're looking at, or option 2, which is that lighter touch legislative reform, is to amend the prescribed conditions and restrictions in the national regulations to include a requirement for notification of change to rail infrastructure and rolling stock, and to have regard to the overall national rail system as a network. We don't have a third option for this one. Recommendation 19 is around mutual recognition, and this is something that comes up across technology, skills, rolling stock. It's a consistent messaging that we've heard, but there should be a presumption of mutual recognition for technology approvals is what this particular recommendation focuses on. So if where technology has been approved by one operator, ideally adjacent operators could rely on that assessment, provided the conditions are similar. If there are genuine differences in environment or risk, only those specific differences need to be tested rather than going through a whole full approval process. It's intended to remove duplication and promote interoperability. Depending on where this one lands, there may also be a need to develop accompanying principles for sharing of costs assessment between operators, because obviously whoever's doing the initial upfront assessment, there's a different cost down the track. The options we're considering here and asking for your input on are around the non-legislative option is voluntary national coordination. So this could be achieved via a memorandum of understanding or guidance material, those sorts of mechanisms. The second option is to include a provision in the law for mutual recognition of technology to enable RIMs and rolling stock operators to rely on others' evidence to confirm suitability for their own network and operations. And we don't have a third option there, but I think that option 2 is a fairly significant step. Recommendation 20 is really around skills and competencies, and this recommendation has many subtangents to it. So the recommendation you can see on the screen is that a national set of competencies be established and recognised by all rail transport operators, but it includes a number of sub-elements here. So we're talking about mandating and awarding qualifications and units of competency for nationally recognised training. Where there are gaps identified, having nationally identified recognised qualifications and units of competency, validating localised training and competency assurance processes, mandating a national competency management system to support mutual recognition, establishing national safe working rules, and making sure that any changes are made at the national level, and also to support all this defining and implementing national rail roles. The overall intent here is to improve safety, reduce retraining burdens, and support a more mobile, skilled, and future-ready workforce. So you can see this is a very complex beast, but the non-legislative option is around a combination of memorandum of understanding between operators, as well as industry codes to support mutual recognition. The second option, or the lighter touch legislative reform option, is a combination of regulatory amendments to strengthen the existing requirements. So there's already a requirement in the law around the issuing of qualifications and units of competency, but to really shore that up and make sure it's used as intended, as well as mechanisms to drive adoption of harmonised safe working rules. The stronger legislative reform is to include in the law a requirement for the use of a national competency management system and imposing mandatory standards for national safe working rules. Now I'm going to talk to institutional governance reform options to deliver both the National Rail Action Plan and the Rail Safety National Law interoperability recommendations through a coordinated, holistic approach. As Jimmy mentioned, the merging of these two makes sense, and it's logical because there's so much interplay, but I'll just step through those 4 areas on screen so that we can explore what those governance arrangements might look like. So the first key area is interoperability assessment of future investments. National interoperability is at the heart of the whole of network level is needed for the NNI as a gateway for investment planning. It recognises that decisions made by local networks can have broader impacts across the system, and oversight of the assessment process and assurance processes will help ensure that infrastructure, technology, rule changes do not inadvertently undermine interoperability on the national network for interoperability. This needs to often occur upfront before investment decisions are made and involve network owners, RIMs, rolling stock operators on the NNI. So the options we're exploring in the consultation RIS are around non-legislatively, National Council, for example, of network owners and RIMs to provide a whole of network oversight and coordination. When we're looking at these governance reforms, some of these options will actually work very well together. So we might have this National Council, but we also are looking at a legislative reform here around including interoperability as part of the sub-duties in the Rail Safety National Law. Because as you can see, this links quite strongly back up to those recommendations we've already just talked through. Driving national standards development and adoption is absolutely fundamental for the rail industry. Effective implementation of the national standards framework requires improvements in how mandatory and harmonised standards are initiated, developed, assured and adopted. Tier 1 standards or mandatory standards will be critical to delivering interoperability objectives on the National Network for Interoperability. Tier 2 harmonised standards are intended to lift productivity, safety and sustainability across the broader network. To support this, ministers have endorsed a strengthened RISB, now a RISO, as the industry-led technical standards setting body. For Tier 2 standards to deliver real benefits, they need to be relevant, nationally agreed, clearly documented and accessible to all stakeholders. And importantly, they must be adopted in practice. So options that we're exploring here is, again, in that ministerial statement or a statement of expectation in relation to the regulator considering harmonised standards and their regulatory task, but also looking at stronger legislative reform around provisions in the law to better facilitate national harmonised standards and network rules. So this could look like giving more legal weight to nationally harmonised standards. They won't be mandatory, but to give them weight similar to a code of practice under the Rail Safety National Law at this point in time. We're also considering options such as giving a RISO, having a RISO membership as a condition of accreditation. So there are some meaty things to consider there in standards space. Skills and competency oversight. As I've gone through above, there's a lot happening in the space, and the review recommended a national set of competencies be recognised across Australia, which will help workers to move across networks and have their skills recognised. But to make this effective, we need an ongoing national function to oversee mutual recognition. This includes monitoring compliance and ensuring quality and consistency of training and competency assessments. So the options we're exploring here is, again, in the MOU space, Memorandum of Understanding, but with education agencies potentially, or a rail industry body to hold national roles and a national competencies register and the national curriculum, and to oversee national training quality and assessment. The complementary potentially recommendation for legislative form is to have a requirement in the law for the use of a national competency register. So again, you can see it links back to those other reforms quite closely. The last key area for governance reform is rolling stock approvals. Again, it's a recognition issue. Currently, freight operators must navigate separate rolling stock approval processes for each RIM whose network they operate on. And this is duplicative, inefficient, costly, can deter investment in new and innovative rolling stock. Last year, ministers endorsed a national pathway to streamline rolling stock approvals, which is a staged reform about clarifying assurance roles and responsibilities, piloting a single national application framework, identifying network info standards to be harmonised, and establishing a national rolling stock register and registration system. A mandatory standard, which would be very much a process-based standard for rolling stock approvals, will also be developed, informed by this national pathway work. So to support implementation, a national coordinating function will be required to administer it, maintain the register, oversee mutual recognition, with that objective of reducing duplication and improving transparency. Options for rolling stock oversight, approvals oversight, is an intergovernmental agreement or memorandum of understanding, some sort of agreement around how that will work at that level, supported by potentially a legislative reform around a provision in the law creating a function to administer rolling stock approvals, coordinating applications, maintaining a system for registration, to make sure that it's all streamlined. As you can see, there are quite a few linkages in the interoperability space between the Rail Safety National Law Review recommendations and the National Rail Action Plan reforms. So I'm going to hand over to Tom, who's going to talk you through a case study that hopefully brings it together in a bit of a story so that it's a bit more consumable.
Thanks, Mel. So really, what's this look like in practice? We've identified that interoperability needs to be in the law, and it means that mandatory standards and interoperability management plan requirements. But something we need to consider further is, does it mean that interoperability should be included as part of the operator safety duties? And in considering interoperability, considering the impact and interoperability with interfacing networks, which may be wider than just the national network for interoperability. Governments and decision makers and owners and RIMs they've got a key role in making interoperability effective, and that we've got to ensure that discussions about interoperability are had before major funding decisions are made and business cases are committed to, so that the right investments are made in the right way and we don't perpetuate the challenge that we face at the moment because of decisions that have been made in the past. The regulator, of course, has a key role in promoting interoperability and looking to strengthen productivity as a principle in the law. Noting safety will always be the primary focus, but need to shift the interactions between operators and also with the regulator to one that lifts productivity. This probably take the form of a statement of expectations and requirements for operators to report on productivity matters. But improving interoperability by its very nature is going to be an improvement to safety by reducing the interface risks that we face on a daily basis which traverse the nation. Harmonised standards are key to lifting productivity, and we know that ARIZO has been given a key role in delivering these, but need to make sure that they're adopted across industry, so we're considering provisions to drive this adoption and encourage take-up. This might mean that Tier 2 safety standards and network rules have a similar legal effect to codes of practice, which Mel touched on before. The rail industry spends a lot of time and effort at a significant cost in improving technology and componentry and rolling stock, and having that ability to rely on the work that other operators have done, other RIMs have done in approving equipment on and technology in individual networks is absolutely key in reducing the cost of duplication, but also having that national mutual recognition right across these areas absolutely vital. And the CRIS explores how this might be done and who might be responsible for looking after these national functions. For skills, we also need national reform and considering national competencies register in a national body to hold national curriculum, and proposing to tighten requirements to issue national qualifications to support workforce mobility as well. Need to work through the changes and need to make sure we understand who needs to have a key role in these areas, including ONSRA, ARIZO, RIMS and RSOs, the NTC and potentially other government bodies. Many of these reforms will need legislative change, and some of them will need to be supported by non-legislative but formal governance arrangement. But it will fundamentally require the commitment of everyone to make sure it happens. And during the, I'll just digress a little bit. During the review, one of the key quotes that someone said to us during the review was, optimizing your own network doesn't mean you're optimizing the system. And really what that means is we each of us need to need to spend a little bit more thinking about the system as a whole rather than our own individual patch. I'll now hand over to Dimmy to keep going with the next slide.
Thanks, Tom. Just quickly around the transparency and accountability sections of the series. As has been previously mentioned, these were key themes of the review. We heard quite clearly that some confidentiality provisions, with all the best of intention, actually inhibit information sharing, which then doesn't allow safety benefits to be realised. So in terms of the options in the series, the first one around strengthening the consultation requirements is, and it's important to note, the focus isn't necessarily on changing who should be consulted, it's just ensuring that that consultation is meaningful and really goes to the heart of people understanding what change is coming. So the first one, the series explores is an industry code or a guideline which requires employers to demonstrate evidence of meaningful consultation. And I note that ONSA is currently consulting on something similar at the moment, but just to make really transparent and clear what good consultation looks like. And then the other option that we explore in this area is amending the RSNL confidentiality provisions to allow sharing between the regulator and industry. There is no third option here in terms of a broader or stronger legislative option. The other key area that we discussed through the review is how interface agreements work in practice, and I've noticed there's a couple of points on the chat around interface agreements. So what the review recommended was strengthening the regulator's powers in relation to the interface agreement to actually bring to life and actually achieve the intention, because we all know that interface agreements are critical to managing safety risks when rail operations interact with other parties, such as shared infrastructure and level crossings, and it hasn't always been easy to get all the relevant infrastructure managers on the same page. And so it would allow the regulator to direct some improvements when no appropriate interface agreement is in place, and it's really to ensure that everyone's safety responsibilities are clearly defined and actively managed. So in terms of the sort of non-legislative option, there isn't one in this case. The first option that we do have in the series is introduce a power for the regulator to be able to ensure parties to an interface agreement comply with the terms of that agreement. For example, issuing improvement notices or imposing some kind of penalty for non-compliance. And then the other option is to introduce a power for the regulator to ensure interface agreements are actually in place, including the power to impose and direct amendments to these agreements, and to amend the RSNL to impose requirements on road managers, enabling the regulator to exercise greater enforcement, including compelling road managers to take action. Next slide, please, Leah. I think this case study just basically reinforces what I said, but I think it's just bringing to life a bit more an interventionist and a more active and clear role on what I think is the intent of the RSNL currently, but perhaps not always experienced in practice by those in the rail ecosystem. In the interest of time, I think we just might move to the next slide and then open it up to questions. As mentioned earlier, we are welcoming submissions until the 4th of May. You can do this via our website. We have a summary document on our website too for those who kind of want a bit of a cheat guide to, rather than reading the great read, which is the long read. We are also at the same time organising a great number of bilateral meetings, which should be appearing in people's diaries for those that have shown an interest. If you do want to have a bilateral meeting with the NTC and Tom, and you haven't heard from us to date, please do reach out and we can schedule that. as always, we welcome broad input from different stakeholders, and in particular, if people have any sort of data or information or evidence that they think will be of benefit here, please do share it so that we can land in the most evidence-based and most sort of practical way in terms of our recommendations to ministers towards the end of the year. But I'll stop there and open it up to questions.
Timmy, we might just go back to the chat and work through them sequentially. So Bala Subramaniam, I hope I got that right. Bala asked a question about the importance of standardising rules, and Bala, I'm just going to pop in the chat a link to our rules standardisation project. So absolutely agree, standardising rules has got to be a big part and is a big part of the National Rail Action Plan. Separate work to this because it doesn't necessarily need legislative support. So hopefully that sort of goes some way to answering your question. So very scrolling down, Ian Mash, disappointing to hear if safety measure, any change must be unambiguously clear that productivity even is a secondary to safety. No question at all. I think Tom picked that up in his comments. So safety paramount, no question. Brendan has asked a question about the mechanisms the regulator would use to act in the sphere of interoperability and productivity. So, obviously, this is potentially complex. I think the short answer is that this is part of the reason that we're consulting at the moment. But I will, Dimmy or Tom?
Yeah, well, clearly what this looks like for the in any way, shape or form, this is a different kind of regulator than the one we see today. Exactly what that looks like is part of this consultation process. I think in terms of regulatory or compliance tools, I don't really envisage kind of new penalties per se, but I think it's about how they take their risk-based regulatory approach and put in that an interoperability lens and a national lens. So I think it's a really good point, and this is part of figuring out exactly what that looks like. Tom, I don't know if you had anything else to add.
Yeah, this is because it's still such early days. Figuring out the best way to ensure that the regulators having a positive influence on interoperability is the key thing. Not making it a stick arrangement, but making it a way of ensuring that as an industry we want to do the right thing, and every investment we make, instead of being another barrier, it's a step towards a uniform network across the nation. And I know I'm a bit of a optimist or a daisy sniffer in that regard, but you know it's of vital importance that every investment we make is a step towards where we want that end goal to be.
Great, thanks, team. We've got a question. So it's Brendan. We've got a question from Maria regarding interoperability within the NTC signalling system. What will be the role of the notified body certification in this context? I certainly can't answer that. Is there anyone here? Tom, you look like you're trying not to say something.
No, it's ideally it's one of those things of having a clear, unambiguous set of standards that everyone follows across the nation. And there you go, Steve's probably far better to answer this one than me.
Steve, and you're on mute. Thank you.
Yeah, I just had to re-enable my microphone. Thanks for whoever did that for me. Yeah, just to say, look, we're not anticipating having NOBOs in exactly the same way that they are used in Europe to support the technical specifications for interoperability and manage around that. But we're certainly investigating, as part of our work on mandatory standards, how governance arrangements would work and how a kind of equivalent setup that achieved the same sort of objectives, but in the context of the Australian operating environments and the fact that we're working within the framework of European legislation. So we're definitely looking at that, but we're not planning to implement exactly the same arrangements as they have in Europe with the NOBOs.
Right, thanks, Stephen. That's one of the things I love about this organisation. There's always somebody who can answer a question that I don't even understand. So I'm moving through the questions again. Daryl's asked a question, significant risk is the interfaces with the NNI. How will the interfaces be managed to ensure consistency, interoperability and harmonisation? I know Dimmy touched on interfaces before. Dimmy, is there anything you want to add?
Yeah.
Or Tom or Mel?
I think this is exactly the point that the recommendation in the review is trying to address, and really to bring a more sort of activist and directive role from the regulator to do that, which obviously would necessitate, sort of a capability and capacity that the regulator doesn't have right now. So that's part of the consideration. But that's exactly the point these sets of recommendations are looking to address.
Yeah, and just because something's not part of the national interoperability network doesn't mean it can't consider interoperability. Things that happen across the nation, across all networks, affect each other.
That's right. Great, thank you. Thanks, team. Ian Mash has asked a question. I don't get how a single rolling stock acceptance process can work when the range of RIMs have, for good reasons, different interface requirements. So Ian, I agree completely. And part of the importance about the harmonisation of rolling stock approvals is going to be to separate the stuff that can be harmonised and should be harmonised from the stuff that is very RIM and network specific. Obviously, the RIMs understand their infrastructure and their infrastructure requirements of rolling stock better than anyone else and should be responsible. But one of the things that we have found out over the last couple of years is that the way that RIMs go about this differs not just according to the kinds of infrastructure they have, but for other reasons as well. I mean, the fact that we've got some RIMs who have application forms that are 7 pages long and some of them are 70 pages tells me somebody's either asking for way too much information that's not necessary for this. Somebody's asking for not enough. And the challenge for us will be to harmonise things that make sense, to make it easier for rolling stock operators in particular, but don't necessarily cut across those issues where the RIM is always going to be, you're going to need something quite specific. What I'm going to do is just pop your question in the chat, and I'm just adding a link to our rolling stock approval project. So just to give you a bit of an update there. All right, back with it. Bala, again, how is it envisaged that interoperability constraints be identified? Constraints emerge through multi-system integration and operational experience, not necessarily through upfront specifications. I'm feeling a little bit technically overwhelmed by that. Is that something that Stephen or Tom or Mel, you're looking eager?
Well, I think this is really the multi-layered approach that we're looking at in the bringing together of the RSNL review recommendations and the governance arrangements, because it needs to be multi-pronged. We've got to have the standards, the technical specifications. We've got to have the legislation underpinning it. We've got to have the governance and institutional arrangements working around it so that the whole ecosystem delivers.
Yeah, great. Thanks. Thanks, Mel. All right. Well, I'm continuing to move on because I know that there's still plenty of questions. Keith has asked a question about why the interface with WHS is out of scope, and I might pass over to Dimmy for that.
Look, I think that within the terms of reference of the RSNL review, one of the things we were asked to look at was consistency between WHS and RSNL. I think that particular recommendation didn't have a legislative bent on it, because what it found was just to be really clear that WHS had its part of the world and RSNL had its part of the world, and really it was just clear to make sure what those boundaries and how it worked in practice was. So the recommendation from the review was just to clarify more clearly how those two how those two regimes worked, rather than necessarily bringing in the legislative requirements into the RSNL. So that one is dealt with outside of the law, consistent with what ministers agreed in the RSNL review. So I hope that answers that question.
Great, thanks, Timmy. Mark has asked a question: to achieve interoperability, winners and losers on costs, is there going to be a nationally managed fund? Without going to the sort of the broad nature of interoperability, the NTC has been asked by ministers to do a bit of work about cost sharing when it comes to ETCS deployment. So part of the work that we did in providing ministers with the advice to say that the national solution should be ETCS for digital train control, the business case work that we did in the economic analysis there showed there was a big disparity between winners and losers, and some parties got huge benefits, and in fact the people who were getting the benefits weren't necessarily bearing the costs. So there's a disconnect between who pays versus who gets the benefit. So we've been asked to come up with a cost sharing arrangement that will work between the Commonwealth and other governments, and potentially industry investors as well. Very early days yet, so I can't talk about the details, not because they're secret, but because we haven't worked them through yet. So really important point. Some work underway, but some more to go under the bridge first. Maria has asked a question: will the criteria for conducting independent safety assessments be standardised by RISO, so that all independent safety assessors apply clear and consistent criteria? And I see that we've somebody's added. Oh no, that was me. Clear and consistent criteria in their evaluations. That's again a little bit beyond my team. Is there anyone who can see Maria's question?
I can't commit to what a RISO is or is not doing, but I can definitely say that there's a prioritisation methodology that's being put together to look at what we do need to have harmonised nationally, so that if this is something that needs consideration, it will be definitely thrown into the mix.
Yeah, and I know we've got a few people from RISO on the call, and because of the limitations of the webinar format, we can't ask them to speak, but perhaps somebody might have a chat into the chat there. But I suspect this is a bit early days to be answering that question. Greg Perrin, is compliance with the RISO national standards in isolation sufficient to demonstrate that risks have been reduced so far as is reasonably practical? Or should RISO standards be regarded as establishing a minimum baseline of risk control, with jurisdictions retaining the authority to require additional reasonably? I think this is going to part to regulatory practice, but the role that RISO standards have and the force to which they have, and how much the regulator can rely on compliance with the standard is something that we do want to test as part of this process. Dimmy, Mel, is there anything you want to add?
Yeah, I think Mel, I have an answer, but Mel has a better one because she's looking to answer. So I'll give Mel the chance.
Yep, cool. Thanks, Mel.
Sorry, just I think it's not ever going to obviate an operator's duty to manage the risks of FAP. They're still going to have that duty. What we're hoping to do is get some agreed that Tier 2 standards are of sufficient quality to be, one of the things we're exploring is to be admissible in court as you've done the right thing, but you've still got to assess your own operating context and take whatever measures you might need in that context. You can't just say, I've applied the standard and done nothing else. That will never meet the need.
Yeah, I think that's a pretty good and important clarification. So thanks, Mel, for that. Brendan's come back with Clover. We've answered some of your questions. This is why you'll flag things and ask hard questions to try and help make sure it works. Brendan, that's exactly why we're here. And the harder the questions, the more we're tested, the more we want to finesse our thinking. We don't have all of the answers, and part of the reasons for doing these webinars, for going out to consult, is exactly because we've got a whole industry of people here who are who know this stuff better than I do, certainly. So yeah, thanks for the feedback, and don't stop with the hard questions. Deepak, rail safety workers using safety refresher training to refresh safety. Why was it not part of upskilling anymore? I suspect that's about specific courses, but I might just go. Do we have is anyone in the team able to answer that? Brad. Oh, I forgot we had Brad here. Oh, that's embarrassing. I'm sorry, Brad.
Thanks, Michael. Not at all. Look, I've just actually responded to Deepak's question in the chat, but broadly speaking, rail safety workers are required to complete recurrent training, usually between a 2 or 3 year time frame. RIMS and RTOs usually set that cadence. Notwithstanding that, ASQA also sets guidelines and requirements in terms of recurrency of critical training packages, which also reflects a 2-year period. But I'm more than happy to have a further conversation with Deepak or anybody else in relation to competency requirements post the event.
Right, thank you, Brad. That's fantastic. That's really helpful. Chris, including interoperability and enforcement as a responsibility for the regulator will require significant additional resourcing. What's the plan for sourcing funding for resourcing those additional activities? So when we get to the end of the series process, what happens is then we will pull together some final advice to Australia's infrastructure and transport ministers. That advice will cover how we think you should respond in a legislative sense to each of the recommendations. And as part of that, and that will then go to what we call a decision RIS, which is where we do all of this again, but with a clear and single proposal about the sort of reforms we need. When ministers consider that, we'll also be providing advice, probably that we will source from the regulator. So we will work with ONSRA to work out, okay, what does this do to your cost base? What does this do to your resource requirements? And my expectation is that we would put that to ministers at the same time. If ministers are going to make a call about this, they need to know how much it's going to cost and what they're on the hook for. That if you want to do this and you want it to work, you're going to need a regulator. So good question. And the short answer is that will be part of the package that goes to ministers. Keith McMahon's ETCS has a number of variables. Difficult. Stephen, can you see Keith's question about ETCS variances?
Yes. So just to answer that a little bit, I guess, yes, I understand what is asking there. There's a couple of pieces of work going on at the moment. One is the development of mandatory standards around ETCS that we're leading, which will include defining the requirements for onboard fitment to suit all types of rolling stock. But also there's some very specific work that we partner with ARTC on that is looking at ETCS implementation on freight locomotives and how that would work in kind of more regional environments as well as across the whole of the NNI. And so all of that work is looking specifically at how we can use ETCS in kind of freight environments to deliver performance benefits and not constrain freight operations in any way. So it's a well understood problem, and we're working closely with people around that topic at the moment.
Fantastic. Thank you. Thanks, Stephen. Okay, so I think we've Keith. Brendan's asked a question about the process by which RISB and Arizo develop standards, and so it needs a lot of work. Now, interestingly, I see Alan Feder has not responded to that, but has made another comment. Without putting words into Alan's mouth, I know Arizo are doing a lot of work about their standards development process that starts with the sort of prioritisation, and Arizo have. In fact, we circulated to a group of jurisdictions and some industry players yesterday, or at least gave them a presentation on how the prioritisation framework would work. In other words, where does Arizo put their resources and which standards does it do first? But Alan also said in that session, and I think has said in a number of forums, how important it's going to be for them to update their process. So agree, Brendan, the process needs further work, and I think Alan would agree with you enormously as well. Renee, following the consultation process, timeframe do you anticipate for the changes to be incorporated into legislation?
Yeah.
I will, Dimmy.
Yes, I just answered that in the chat. So for others, we're hoping to get the final policy positions in a DRES by the end of this year. Once ministers agree to that, we can start drafting. Depending on the complexity of the drafting period, we expect that through 2027. There'll be obviously opportunities to consult on the draft bill, which is when you actually see it in black and white, what it looks like. And then subject to ministers agreeing to that, I would envisage sometime in early 2028 or late 2027, it starts its parliamentary process through South Australia.
Right, thank you. And I see others have been sort of answering questions along the way, including Alan, by the time I was speaking, had already talked about his work to redesign the standards development process. Go through, and Brendan's just made a comment at the end. Like the process of slowly creating tiered standards to progressively help the industry make sensible changes at the right time. Absolutely agree. And part of the ARISO prioritisation framework will include a test about how strategically important is this now, but also tests of industry capability and is this the right time to do this, and how do we sequence things, because sometimes you'll need to standardise something A before B, if that makes sense. Now it's 1:58 and we seem to have exhausted the questions, which is I think a fantastic effort on everybody's behalf. I'd like to claim responsibility as chair, but that's just nonsense. So look, thanks everyone for taking the time to join us and for the really important questions and discussion we've had. Coming back to the earlier comment, the harder your questions, the harder we've got to think, the better the outcome's going to be. So please don't moderate your questions. Together, the RSNL review and National Rail Action Plan represent a pretty significant shift towards a more coordinated national approach to rail, but how we implement these changes, and not just the decisions to make them, but how we implement them will be absolutely critical. So as Demi said, we've got the RIS is open for public consultation until the first week of May. So encourage you to take the time. There is also the short version available, but you know, who here doesn't want to read 89 pages of rail safety nor RIS? I certainly do, and I know you guys will as well. All right, it is now 1:59. Can I thank everybody? Can I thank the team for helping me answer the question? Melissa, Tom, Dimmy, Stephen, Brad. Thanks to Leo for steering the boat. And I see we've got a couple of, who else have we got there? Did I just, oh no, we've got, all right. That's the quietest round of applause I've ever seen. Thank you very much, everyone. That's fantastic. All right, thanks for joining us. And
thanks, everyone.
Keep focused on RSNL and the series. Thanks very much. Cheers.
Thank you.